Good afternoon. It's always great to be the first person after lunch. Hopefully I'll be able to keep you up. My name is Matthew Dietz. I'm Litigation Director of Disability Independence Group. Disability Independence Group is a nonprofit legal advocacy center for persons with disabilities, and we're centered in Miami. Most of the work that we do is advocate and litigate on behalf of persons with disabilities to ensure that they get their rights under the law, whether it's Medicaid, whether it's the Americans with Disabilities Act, whether it's the Fair Housing Act, and other laws that protect persons with disabilities. We also have other programs and services. For example, we study the issues with regards to domestic violence in persons with disabilities, and also we have a wallet card program where we've been assisting persons with autism in police interactions now, and our program has given out over 3,500 cards. But today what I'm going to talk about is issues that I have experience in doing as a litigator. This is how to ensure that all of the disability-related needs are met through the ADA. And please, if anybody has any questions, feel free to interrupt me. I'm really good at that. Children with disabilities have the same rights, benefits, privileges, services, and programs as any other child should have, and they should be provided with the resources necessary to live and grow both physically and psychologically in a community-based setting. That is the basis of what we have and what we do. We have to look to see what everybody else gets, and kids with disabilities should have that same ability to grow and thrive in the community. What is the ADA and how it can be used to advocate for children with disabilities? What we're talking about when we're talking about the dependency system and the child welfare system is we're talking about Title II. Title II of the ADA deals with local and state governments. Title II of the ADA is very broad. The law is extremely broad. The regulations are just a bit narrower, but not much. It says that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or denied the benefits of the services, programs, or activities of a public entity or be subject to discrimination by any such entity. The important issue here is what are services, programs, or activities? And we'll go into that. How is a disability defined? It's a three-pronged approach for what is a disability. A disability is a physical or mental impairment that substantially limits one or more major life activities, which would be considered to be an actual disability, a record of having such a disability, or when somebody regards somebody as having a disability. And regarding, as we're going to talk a lot, especially after listening to Steve Silberman, because I think something that's really important in building on what he said is what is a stereotype, and how do you determine what's best for a person with a disability, whether it's autism or whether it's another disability. Now, this is something that I like. Full and equal opportunity to participate. People with disabilities must be provided with the same opportunities to benefit from or participate in a court's program, services, and activities, or any program and activities as an individual without disabilities. And this picture shows that everybody is entitled to pick a piece of fruit, but some people need a little bit more assistance than others. And that's what the ADA provides. And when you look at equal opportunity for kids, you look at all of the programs and activities in a certain group. What do people get? What are the services, programs, and activities? In family law, parenting classes, counseling, visitation, dependency, reunification programs and services, how do you make them equal? medical care. What medical care does a child need in order to fully take advantage of the program, service, and activities of a public entity? And court proceeding, how do we make those accessible? And this will cover any type of service. And I'm going to move off of my PowerPoint pretty soon, and I will go into more individual stories and stuff like that, because it's always a little bit more exciting. Investigations, witness interviews, assessments, everything on the whole list, these are all activities. So when you look at an activity, you should look at the activity or program and say, how do we make that activity or program equal? And the final thing before I start talking about more interesting things is stereotypes. What we deal with in disability law, disability rights, is what people's perceptions are of a person's ability without actually knowing what those person's ability is. It's like when Steve Silverman was talking just before about people being neurodiverse and neurotypical. People are different, and sometimes the differences that people have are not disabilities. And sometimes a person with a disability can do what they need in order to get through to the service, and sometimes that person with a disability needs an accommodation in order to get there. Now let me tell you about something that just happened to me 2 weeks ago. I got a call from an attorney ad litem, and the attorney said they represent a child whose mother has spinal ataxia, which is similar to cerebral palsy, and she just gave birth to a child, and at the child, the nurse called the CPI in this county, and the CPI said, well, the mother has a disease. It looks like she's developmentally disabled. The child's at risk of medical neglect. Let's start a shelter proceeding for the child. Nothing wrong with the mother. No one spoke to the mother. No one asked her, what other supports do you have? No one said, no, they didn't even know that she had no mental disability whatsoever, because for spinal ataxia, her speech was slurred. It doesn't mean that she has a disability. So in just looking at that person, they assumed just because she was a person with a disability in a hospital giving birth, that she was not able to be a parent of that child. Now, they brought the shelter proceeding against the mother, and the judge knew his stuff, which thank God, because sometimes they do, sometimes they don't. And the judge says, no. There's no proof that this woman is unable to take care of her child. She has family supports. This woman is entitled, and wrote this on the bottom of the shelter order, this woman is entitled to all the services she needs, if any, under the ADA, and deny the shelter order, which is wonderful. But when you talk about real and stereotype, you look at that and you say, is that person a person with a disability that has needs? Or are we just, putting our own perceptions of what is normal on that person, whether that person could or could not raise a family? Now, there's some cases now up in New York that I absolutely love, where people with Down syndrome want to become parents and have families. And the question was to the guardianship court that reviewed whether or not they should have a guardianship, whether or not they have the right to be out in the community and to love and to marry and to have a family. And the guardianship judge did a wonderful 20-page decision in saying how it's an essential human right to be able to love and to be able to have a family if possible, and possibly even having supports. Persons with disabilities have the right to bear and raise their children. Children cannot be removed from parents based solely upon the disability of the parent or child. States are required to provide support to these parents to care for these children. In the materials that I submitted with this, and you'll see I have some reports that were done that go in detail in a recent report about parents with disabilities and their children. Now, I'm going to play a video. How many of you have seen the Oscar award-winning film, The Silent Child? Oh man, let me play the trailer for you. It's phenomenal. If I had 20 minutes, I'd play the whole film. So, Silent Child is an award-winning film, and once we have someone fix the volume, I'll tell you more. We could watch the trailer. It's about a 6-year-old little girl in Britain, but the issues in Britain are no different than they are in the United States with regards to children that are deaf. This little girl was brought up as, this little girl was deaf, and her family never did anything for her, didn't provide services as a person who is deaf. So they never provided her sign language services in school. So the video, which is a 20-minute video, which you should all watch, it's $1.99 on Netflix. It shows the issue the child has in being part of her group and part of society, and the importance it is of a child who is deaf to learn sign language. And when you see that from a 6-year-old, how a 6-year-old can't play, can't be with her peers, can't do things like that, and you and you look at it as a GAL, and if you were in that position, what would you say? Would you say that child is entitled to some type of accommodation? And what is in the best interest of that child? So it actually won an Academy Award because of its because of the power of the video and the importance of sign language to a little girl.
You have not remembered properly. Anything we're saying. Susie, I backed you up.
We only found out she was deaf when she was 3.5, which probably makes me a bloody awful mother, but Libby follows what we're saying really well.
Right, well, I'm sure she'll be fine then.
We have quite low expectations. We just want her to be a little bit more confident in time for school.
I'm just wondering if we should be focusing more on the lip reading rather than the sign language.
She is normal, she's just deaf.
Do you think she'll be able to get a job one day?
Yeah, I think she'll be able to have a career in whatever she likes.
Oh, God bless her.
Now, the issue of children that are deaf is a big issue because many times children that are deaf grow up in a home where nobody else can speak sign language. And the children grow up in homes in which sometimes they have minimal language skills, and they learn what they do through the schools if they are provided services. So in many situations when you're dealing with a child who is deaf, the question is, what is in the best interest of the child? What services does that child need? What services can you get from the public school? What role does the court have in looking at that, in looking at what that child needs? When we look at little Maisie, whose name was Libby in the film, you would say, is a child receiving the services that child needs from school? Should that child be learning sign language? Should that child be learning some other form of communication? What can we get from the court? What is that child missing? It's not limited to disabilities like children being deaf or children being blind. Let's look at what Steve Silverman said. What do you do when you have a child who is autistic? What services should that child get in order to participate? What do you do? How do you know what services are appropriate for that child? I will bet you if you called up the group that Steve spoke about, Autistic Self-Advocacy Network, they would say, we don't believe in ABA. We don't believe in behavioral therapies. We believe that the child should grow up just the way the child should. On the other hand, if you went into an IEP meeting, there's no question that they would say, you know, we need to stop that child from flapping his hands. We need to do everything that we can in order to stop it. There's many different views of what needs to happen. And then it gets a little bit difficult as to what are the child's needs. And it's very controversial. This film, The Silent Child, was controversial and is controversial because they said the child should learn how to lip read. The child shouldn't learn how to do sign language, but the effect of the child not learning how to do sign language is the child was depressed. The child could not be integrated with the child's peers. And it's still an issue that we're having in Florida now. What is appropriate? Is it appropriate to be orally based? Or is it appropriate to learn sign language? Now, I advocate for a lot of deaf people, and they would be jumping up and down, and they would say, if you don't use sign language, they would be taken away from the community, from everybody else there who's deaf. So it's a difficult question as to what is in the best interest of the child when you're looking at now with people saying in the disability community that we should be more ourselves, we should be not told not to flap our hands, we should not be told how to act, or we should learn how to do sign language and we should be a part of the deaf community, versus the non-disabled community imposing their own beliefs on what people with disabilities should be like. So that makes it a little bit tougher on what you should do and what you should not do. But the question is, in your position, how do you do it? So now that I've gotten you utterly confused about what is right and what is wrong and what's in the best interest of the child, because everybody has different opinions and it's an individualized assessment, how do you get the accommodations you need? How do you determine what accommodations to request for your client with a disability or your child with a disability? Number one, speak to the child. Ask your child about his or her disability and to find out what accommodations that child usually has. Most important thing, don't rely solely on parents, caregivers, family, or friends to determine what's the preferences of the person with a disability. You have to remember that you are representing the person with a disability. You're representing the child a lot of the times. When you represent the child, when you're for the child, listen to what that child wants. When you do listen to or look at The Silent Child, you'll see the child enjoys communicating in sign language. The child grows, the child becomes interactive. When the child's taken away from her language ability, she becomes withdrawn, she becomes depressed. So even if a child is 5, 6, 7 years old, that child has needs and wants, and that child can express what works best for that child. So number one, speak to the client. Don't solely rely on parents, caregivers, families, or friends to determine what the preferences of a person with a disability is. Let me give you an example of that. Every month, Disability Independence Group does a dinner. in the community, and we invite all folks with all neurodivergent folks that are in the community. You have a developmental disability, you have an intellectual disability, come, let's have dinner, let's talk. We try to get the people with a disability away from their parents or caregivers, so the parents or caregivers don't speak for them. It always happens. The parents and caregivers feel compelled to be a parent or caregiver, whether it's right or whether it's wrong. We find that happens a lot when we're dealing with clients with disabilities and dealing with domestic violence. When you have a caregiver, a spouse that's able-bodied versus a person with a disability, there is occasionally overreaching there. And we always have to watch to determine whether or not there is abuse, whether there is domestic violence there. And one example is I once represented a deaf woman, and her boyfriend wanted her to have an abortion. And the boyfriend went with her into the family planning clinic, and the boyfriend talked for her throughout the entire process because the facility never got her an interpreter. They used the boyfriend, the speaking boyfriend, to communicate for the deaf woman so she could have an abortion. These are things that commonly happen. This is not unusual, and it happens in many medical environments. In fact, I've had 8 cases in front of the 11th Circuit Court of Appeals solely on the issue about the types of communication a medical professional has to have with a deaf person and the quality of that information that the deaf person is allowed. And the answer, as it's coming through the court, is they're entitled to have an equal opportunity, the same benefit that a hearing person would have if that hearing person went into the facility, the same understanding that that hearing person is supposed to have. So it's important whenever you're dealing with a person with a disability to speak to them. The taking away the self-determination of a child is not a good thing. Part of growing up as a person with a disability is to have that individual right of choosing, that individual right of choice. Yesterday, I visited a client of mine in a group home here in Orlando. The client was originally incarcerated, and he was pardoned because he was autistic. Part of his pardon was he needed to go into a group home, and he goes to me. And he says, Matt, when I was in prison, I knew when I was going to get out. I don't know when I'm going to be able to leave here. They told me before I met him that he was a person with an intellectual disability. And then after he said that, I said, no, you're not a person with an intellectual disability. That was extraordinarily profound. He has autism. He has severe limitations with his autism. And because of that, and because of his autistic behavior, he was incarcerated for a number of years. But it was easy enough talking to him and saying, what can I do for you? How can we get you to a period of independence that you need? What services are available for you instead of being here at this group home? How can we get you into an apartment and get you the services you need in being in an apartment, whether it's a life coach, whether it's a job coach, whether it's other programs and services that the state has in order to move him on. But the important factor in this is to speak to the person, to see what they want, to see what will lead to independence. And it's a much different story when you're speaking to a 6-year-old than when you're speaking to a 15 or 14 or 16-year-old who's going to know what they want. Another interesting case that was a couple of years ago against the law school examination folks, and it involved a blind woman. And the blind woman, and what she wanted as part of taking the MPRE, which is a test that lawyers take for professional responsibility. What do you see? Yeah. It's been such a long time, I forgot the tests I used to take. I was thinking, did I take that test? But for her entire law school, what she used is she used a screen reader on her computer. And for those who don't work with the blind, a screen reader is like on every Apple product now. If you want, you do your accessibility settings, and you can actually have whatever's on the screen read to you. So in taking the exam, she would use her screen reader, and she would be able to have the rate, control the volume, control starting and stopping, and being able to answer the questions, and being able to respond back. The multi-state folks, or the professional responsibility folks, who was either which one, I forgot, said that, we're not going to allow you to use your own computer because we don't allow anybody to do that. So what we're going to have a reader for you. And a reader is going to read every single thing that's there. It's the same thing, don't worry about it. The woman brought it up to court, filed a preliminary injunction, says, I've never used a reader before. I've always used a screen reader. It's going to affect how I do on the test because this is the accommodation I always use. And the court agreed with her. The court said it wasn't fair and there was no burden for her to use the computer, the screen reading software on the computer. So when I say that when a child gets older and when an adult is an adult, they're going to know what works best for their disabilities. So without talking to the child about what works for them, you're doing a disservice to the child. Number two, most important thing, and this is what everybody doesn't do correctly, determine the needs of the child through the barriers to the program and services. What modifications are needed to existing rules and services because of the child's disability? Is there anything that this program and service could offer that would lessen or ameliorate the child's disabilities? And what services will the child need in the future? Let me give you an example. I currently have a case now in front of the 11th Circuit Court of Appeals, and it's probably going to be tried in the next year. It's against the Hillsborough County Sheriff's Office and their CPIs. I represented a little girl who is 14 years old. She had cerebral palsy, and her mom had a bad back. So not only was the mom a person with a disability, so was the child. The mom had trouble lifting the child up in the middle of the night. She had 16 hours of home health care, and she needed additional care in the middle of the night so she can care for her child. The CPIs came in and they said, nope, we're going to shelter her, took the child away, sheltered the child in Tampa General Hospital, went in for the shelter proceeding, and the court said in their order, the child should get an additional 7 hours of care at night. And then they set the dependency trial within 40 days. And what happened is the CPI and nobody else got the additional care. They tried. They made one call and were told 24-hour care is not approved for anybody. Don't even try. So they didn't. The child was taken without court order to a nursing home within a week, and the child died when she got to the nursing home. And the question that we're in court now is what role, number one, what role did the state have, or the CPI, or the CBC, in providing that additional 8 hours of care? That's number one. Number 2 was, did they violate the child's Olmstead rights? And we're going to get into Olmstead soon, because Olmstead is one of my favorite things under the ADA. And to stay out of a nursing home, to be out of institutionalized care and be in her own home. And the interesting issue is and the issue that's in appeal, and this is all so relevant to you guys as guardian ad litems, is who is responsible for this? Under the ADA, everyone. If you touch it, if you have the ability to make the change, if you're providing the program and service, you're responsible. If DCF is saying, DCF, we're making the CPIs and the CBC jointly responsible for our actions, both of those entities are responsible, as well as DCF and the state. So under the ADA, everybody is responsible. The state is responsible, and any organizations from the state is responsible for providing that service. But what service is it? We're talking about programs and services. And this is one of the main elements in the case. Are we talking about the individualized service, which is the additional 7 hours health care and the obligation to provide the 7 hours health care, or are we talking about the generalized services of Chapter 39? And when we're talking about a person being put in the dependency program, is the generalized services of Chapter 39. What is the whole goal of this? What is the goal of the dependency system? It is to reunify families, to make sure that people are acting in the best interest of the parent. And if we're saying, if the goal of the system is to reunify the family, and the court said in order to reunify this family, you have to pay an additional 60 hours or 50 hours a day for somebody on minimum wage to sit with this mom, that's a reasonable accommodation. So this is the mind-blowing part. You look at the overall nature of the program, the overall program and the benefits of the program, and you say, what do we need in order to achieve reunification? What services can be provided in order to do that? And that's what you look at when you look at the program. You look at the overall program. You don't look at the individual portions of the program. And then you could get a lot more for your child. And what programs are going to be involved in the future? What do you need? Develop a plan. That's what I do for all my clients. What do you need in your education? What do you need what additional things do you need at home? What additional medical issues? And you come up with a plan to see what you need. 3, how do you get it? Ask the court. I love asking the court because the court's going to order it. The court said in my case involving the little girl, provide 7 more hours. Now how the court should have changed it in order to make it more definitive is the court should have said, pursuant to the ADA, the child needs 7 more hours of care in order not to be institutionalized. That would have been a slam dunk for me in federal court in suing under the ADA. But that's why it's important when you, yes?
How does the court have the authority to order that?
Because they order it under the ADA and pursuant to Chapter 39. You're not ordering the entity to provide specific services. You're ordering the entity to comply with the federal law, and they could do that. Yes?
All right, so you have a parent who is receiving the service, correct? The mother has someone helping her for 16 hours a day.
Correct.
But you're classifying the child as coming under the ADA and asking for the additional hours of accommodation for the child. And that's how it comes under
Correct.
So if the child does not come under ADA, how do we get there?
Associationally. By association. The ADA doesn't only cover persons with disabilities, it also covers folks associated with persons with disabilities. So let's say instead of having my, let's say the mother in my first case, the one with spinal ataxia, child's fine. Is the mother entitled to an accommodation in order to care for the child? Or should the mother or should the care be taken away from the mother? And the child would be qualified to claim those as a person associated with a person with disabilities.
So assuming that the only risk to the child is that 8 hours, then we could use, by association, under the ADA, to get our circuit court to order the child welfare agency to provide that 8 hours coverage.
Correct.
Okay.
In the case that I'm litigating now, the court found that it was a violation of the ADA when the CPIs took that child to the nursing home. And the issue that we're dealing with is who's responsible and what measure are they responsible for other accommodations. But the taking the child to a nursing home, the court found was a violation of that child's rights under the ADA. The part that we're appealing now is whether or not the state has sovereign immunity for those functions. And the second issue is what extent did the state have authority, well, to what extent does the state have to provide the accommodations for the child? But there's no question in that the state has that responsibility to do it, just like any other function of the state. For example, let's say a person goes to court and the person in court needs a sign language interpreter to participate. There's no question that the court would have to provide that sign language interpreter to have that person participate in that program and service. But then it goes further. Let's say there's a parenting class, and you have parents that are deaf that need to be in a parenting class. The court has that obligation, or the provider has that obligation to provide interpreters for that parent to participate in that parenting class. There's not too much of an extension to say that that parent also is entitled to the additional services to be a part of, to take advantage of the reunification process. And where this happens a lot in dealing with parents, and there's about 5 cases in the past 6 months across the country with parents that have developmental disabilities. And I can't ramble off the states now, but they were all on my brief, and I was so excited to see them for the case that I have in front of the 11th Circuit. And the courts have universally said that these parents are entitled to extra parenting classes. They're entitled to extra, one second, I think I have it on my next slide. They're entitled to additional hours on case plans. They're entitled to additional life skill classes. They're entitled to additional testing. And it's not the children, it's the parents. Can they be adequate parents if they have a developmental or intellectual disability? And in some of these cases, what the court says at the end is the court says, even though the parents were provided the additional classes, even though they were provided the accommodations, even though we went above and beyond to see if they could be parents, we had the dependency trial, and in looking at all the evidence and looking at the experts, they found that they couldn't. So it doesn't give them the right to be parents if they're not good parents, but it gives them the opportunity to have the additional accommodations in order to see if they can become good parents. And that's the issue that's involved. So When you ask for an accommodation from the court, use magic words. Under the ADA. Under the ADA, under the Rehabilitation Act, which is similar to the ADA but it's been around since 1973, we need this accommodation in order to have participation in the program and service. It helps me a lot when you're later and you say, but Your Honor, this was an accommodation under the ADA. This is something that she needed in order to keep her child at home. This is something that the child needed in order to succeed where the child is. Does a child need additional training? Does a child need additional tutoring, additional therapy in order to stay at home? It's something that needs to be asked for, but it should be asked pursuant to the ADA. It will put the governmental entity in the court on notice that these are the child's rights. This is not something that will make them feel good. It's something that will give them the equal opportunity to participate in the program and service being offered. And there's a huge difference between the two. Documentation. A doctor saying so, a doctor providing the nexus. You need to prove, in order to ask for an accommodation, in order to have an accommodation granted, you need to establish the nexus between the disability and the accommodation requested. So it just can't be something, again, that's wonderful and terrific and it's something that would really like a puppy. And you ask the judge, I'd like a puppy because it'd make you feel good. It's not going to be enough. You have to have a nexus. You have to have a letter. You have to have documentation from a medical professional. And then the court could order it. If the entity decides that they're not going to provide it, then you have a bigger issue. It gives you more of an issue to go up on. It gives you more of an issue to bring up. It doesn't hurt to ask it, but rarely will a court say, we're not going to provide it, because the defense is, and this is the next issue, the defense you have for a reasonable accommodation. Now, it goes to what the ADA says. If you say, I want an accommodation under the ADA, the question then turns to the entity. What could they say to deny it? And the only defense under the ADA that they could deny something is if it's an undue financial or administrative burden. What is an undue financial burden when it comes to the state of Florida? That's a pretty tricky question, isn't that? What's an undue financial burden when it comes to a large child-based care agency? What is an undue financial burden when it comes to a state agency? It's a difficult question because you look at the overall financial resources of the agency to determine what the undue financial burden is, and some agencies do have additional funds out there to fund some issues, but not all issues. And what I found, especially in the case that I just had, was they had funding for clothes, they had funding for transportation, there's funding for gift cards, there's funding for trips, there's funding for this, but there was no additional funding for disability-related services. Yes?
Where is the school district burden in this? Aren't a lot of the things you're talking about not the dependency of Florida responsible, but really the school district burden?
Absolutely. Absolutely, and that's why it's important also to participate in and look in the child's IEP process and what should happen and the question is, how can you use the court to advance services and therapies provided within the school district, which is a huge question and a very important question, and you do the same thing. I mean, if you have the court say, this is a reasonable service, the problem that it's always tougher with schools in my own past experience because schools don't provide all the services you need, and all the people that sit around the table on an IEP meeting think that they know more than the parent, right? So then you get the court to say that, that a certain service, a certain therapy is a necessary service.
They're not usually there, you have to keep that in mind. They're not always there. They're not there at the dependency.
The parents?
The school district.
Oh, no, they're not. But then you have an order, you have something going back to say to the school district, well, the court said that this was reasonable. Tell me, Miss ESC head, how is this not reasonable if the court did say it was reasonable? So I mean, that would be the thing that I would pull, especially when you're dealing with school-based therapies, you're dealing with assistive technologies, you're dealing with ESY, you're dealing with other things that you need from the school district. To the extent that you can get somebody that has a little bit more juice to help you in the IEP process a lot better. The problem that you do have in the IEP process is if those services are denied, you have to go through due process. And you have to spin your wheels in other ways when it takes so much longer than even at many times the entire dependency process. Yes?
Well, of course, but I'm seeing a lot of dependency children that pick up criminal charges and are deemed to be incompetent, and then they've got this restoration of competency thing. Have you encountered any of those? Because I just cannot, I can't yet wrap my mind around if you have an intellectual disability, in other words, low IQ, and you can never have your competence restored, and placing them in a residential facility and continuing to do that and testing them every 6 months. Have some of those?
Oh, gosh, yeah. I have many issues with the Baker Act. I have many issues with restoration of competency. I have many issues when that comes with folks that are deaf as well. Because people that are deaf that don't have language abilities are deemed to be linguistically incompetent. And it usually becomes a battle of the experts, whether they are or whether they're not competent to proceed. I think we have a huge issue in the state with regards to the overuse of the Baker Act, especially with children under 10 that don't provide any. I'm still like wondering how a 5 or 6 or 7-year-old could be a serious threat to the health and safety of others. And we're involved in some litigation involving that now under the constitutional basis, whether or not that's constitutionally allowed in order to do that. If the criteria for Baker Act is as high as it is, the reason why it is because of the constitutional protections. With regards to arrest and competency evaluations, it's a battle of the expert. There's very little that you can do other than to prove that a child is incompetent to proceed, and then hopefully they're not going to bring it back.
If the facility basically trains them to parrot what a defense attorney does, what a prosecutor does, what a judge does, and you can train just about anybody to repeat those things, and then they call it that their competency is restored. And then you're right, you get into the battle of the expert, and if they delve far enough, they can see what they really know what that is.
Well, I'm involved in a case right now involving a 10-year-old over in Okeechobee County who was arrested and handcuffed from school and charged with a felony assault because he scratched his one-on-one aide's arm. And because we're actually fighting it in the delinquency and going through that issue, they charged him with more crimes. So it's part of the issues that we have within the systems we have, but you're going to be getting a lot more from on the dependency side than on the delinquency side. With regards to the delinquency side, there's also an obligation within the courts to comply with the ADA. So to the extent that they need additional services, you could ask, and there's nothing prohibiting you from asking. Now with the courts, and we're going to go back to this in a second. With the courts, the issue is when it comes to the proceedings themselves, there's a rule in the courts, which is Rule 2.540, which is a rule that I drafted for accommodations within the courts themselves. So parents and children are entitled to accommodation within the programs and services, and you could go to the courthouse ADA administrator and ask for those services, and you should ask them from the ADA administrator. When it comes to issues within the proceedings themselves, such as continuances or issues that the court would control, you have to go to the judge for those. But there is a way to get accommodations within the court system itself. Undue financial and administrative burdens, it's a high standard under the ADA. It must be made by the head of the public entity or his or her designee, considering all the resources available for use in the funding and operation of the service, program, and activity, and must be accompanied by a written statement for the reasons for reaching that conclusion. And even if that accommodation is denied, the entity has to grant such accommodation that will not result in such an alteration. Now, an example of an alteration is you don't have to have, the state doesn't have to create a whole new program for a child with a disability. You don't have to have a concurrent autistic program and an integrated program if an integrated program that accommodates a child exists. It would probably be an administrative burden in order to create a whole new program for a child with a disability. But it would not be a burden to ensure that that child with a disability is integrated into the normal program. One of my favorite things, and we talked about it a lot for last year's, is dogs as an accommodation. Oh, I've been doing so many things about dogs. I've never thought I would become a dog lawyer, and that's what I am. And the question that we're working on now, and this is pretty cutting edge, dogs as an accommodation for a child's disability. When would that be allowed? When would that not be allowed? Under the Fair Housing Act now, there's many cases that talk about emotional support animals, and I'm responsible for the appellate law on many of them. And with those cases, it holds that when a person with a disability has a condition like depression or anxiety, and that person needs an emotional support animal, that dog should be allowed under the Fair Housing Act. And the only thing that you need is you need to have a nexus to prove the connection between the disability and the effect that the dog has on that child. So the question that we have now is whether or not it would be a fundamental alteration or an undue burden to allow a child to go with his or her animal to a foster placement or a group home. And these are issues that really haven't been litigated yet. And the issue is, what burden would that be? How would that change issues? The Guardian Ad Litem program has been working with folks up in Tallahassee to do polling of foster parents up in Tallahassee to ask them, what do they think about this? Most of them thought it would be a phenomenal idea to have a child with a dog or a pet. It would help the child, especially through the hardest times of their lives. And under the Fair Housing Act, if you're providing housing or program requiring housing, that would be part of the program. So this really hasn't been litigated, but when you look at the issues that we're dealing with, and dealing with accommodations and disabilities, and not only, disabilities that are like autism or deafness or blindness, but depression, anxiety, PTSD, a learning disability. When would an emotional support animal be something that would be part of the service or program? Now, what I believe that parents, foster parents or group homes should be given the option to do it, asked. I think children should be asked, and CPI should be asked about the status of a pet in a home. What is the connection between the pet and the child? What effect would it be on the child if the pet was taken away? These are questions that should be asked, and if a child does suffer from depression or anxiety, that would be an accommodation. And there's no reason why it wouldn't be. The only issue is, would it be a fundamental alteration or an undue burden? For one foster home, it may be. For another foster home, it may be fine. Would it be an undue burden or a fundamental alteration for a CBC or DCF to pay for dog food? I want that case. I'm wondering, would it be or would it not be? Would it be if having a dog is better for a child than psychotherapy and cheaper? Would dog food be cheaper than having a doctor? See, when we're talking about disabilities, one of the reasons why I love it, and I love to talk about it, is it's always changing and it's always new. People get new insights on what's necessary. People get new insights on things that help people. And my issue in doing that is, as long as it helps and as long as it improves someone's life, why not? Yes? Am I going to pay for the study? I want a grant. I actually, if you know anybody who has a grant, I'd love it. And also, there are organizations like Mars that has all the pet food that does a ton of things with that. And I think that it would be a phenomenal issue. But even if you don't have a study, under the Fair Housing Act and the ADA, all you need is a doctor's letter. So a study would be great in order to build the case that Medicaid should pay for this service. And that's the only way you're ever going to get Medicaid to pay for the service without having an empirical study on it. But for the Fair Housing Act, we're going to be in a position in 4 years where people are going to ask me, you know, I have an 18-year-old that smokes marijuana. Is that allowed? Can they do that at a foster home? Can services pay for marijuana? And that's going to be the next thing coming up. So that's why my job changes every day. Yes. I had another question here.
It was about the medical necessity of Medicaid. Let's tie together whether any of these types of accommodations have been attempted to be paid for through Medicaid. I mean, obviously other more traditional ones have, but
That's a phenomenal question, and let me tell you why. Because the state usually does that. The state usually says, you know what, if Medicaid doesn't pay for it, we're not going to pay for it. And that's the problem that I ran in my case. They said, you know what, Medicaid doesn't pay for 24/7 services, never had, never will, we're not even going to appeal it for you. And they were wrong with the statement, first of all, but the issue is some of these services are paid for Medicaid, and then there's an obligation to get the assistance to apply, and even if necessary, to appeal the denial of the Medicaid services through a fair hearing. And that's one thing that should be done with kids with disabilities if they're not getting the services they need, because a lot of times, especially when they're EPSDT services, the 32 required services, if you file the fair hearing and prepare for the fair hearing, the entity, the healthcare coordinator, and the name slips my head now, whether it's KeyPro or whoever it is going to drop the hearing. You have to file the request for fair hearing. You have to get somebody to stand behind you to say, these services are medically necessary. And if they fit within Medicaid services, that's something that the process has to be delayed until that's obtained if there's a dependency issue pending. And if there's not a dependency issue pending, then you know, you just push forward and fight for it. But I believe that it's part of our responsibility that if something is denied, to say, why? If it's not paid by Medicaid, it doesn't stop the state's obligation for paying for a necessary service. Then the state has to get the money somewhere else. It's not your responsibility to find the money yourself if the state doesn't pay for it. The only time that the state doesn't have to pay for the service when it is pursuant to the ADA is when it is a fundamental alteration or an undue burden, which is a high standard. The other issue that can be made is we can't continue to pay for this service indefinitely, which is true. But throughout the process of a dependency proceeding, throughout the process of developing a case plan, there may be a temporary time in which some services should be provided. It shouldn't be permanent, should be until something permanent can be done. Olmsted. Olmsted, I love Olmsted because I was involved in this case that I'm still involved with, which will probably go until I retire, which is getting children out of nursing homes. In 2011 and 2012, the state used to remove home care services from children that are medically fragile and put them in nursing homes. So there were about 400 to 500 children plus in nursing homes at any one time in the state of Florida. And it was especially acute when it came to children in the foster care system. That's where they placed them. And they would get the care that they need in nursing homes. And what we basically said is these families should have the option to have their children at home with appropriate home health care service, even if that home health care service is 24/7. And eventually the state started providing the 24/7 home health care service and is now trying to moot out the case. But the good thing that affects about 3,500 children in the state of Florida that are medically fragile and medically complex that need home health care services at home. What the state would say with regards to them is it was for the convenience of the caretaker. So when you have a caretaker who's a mom, we felt that it wasn't appropriate for mom or dad or sister or brother to aspirate a child who needed medical care rather than needing rather than providing parental care. And there's a difference between medical care and parental care. So the issue with regards to Olmsted is it's a child or a person has a right to live in the least restrictive environment rather than being in a institutionalized setting such as a nursing home, such as even a group home in some points. If they can get the services they need to be at home rather than to be at a different home, those services should be provided. When it comes to nursing homes, you're dealing in a situation in which it is more expensive to have a child in a nursing home than it is to have that same child in their own home. And also a child that lives in a nursing home becomes depressed, has a shorter lifespan, becomes sicker than if they lived at home with the necessary care that they do, because children need love. Not very scientific, but that's my own opinion. And there still are children in nursing homes because parents want them there on some occasions. And it's the parent's choice about where a parent should be. But I believe currently most of the foster kids are not living in nursing homes. They're mostly there, and then there are medical foster homes as well, which is a much better placement than nursing homes. And it would really, this is one of the children that I saw that I'd been at a nursing home, and there were rows of beds and children in beds and rows in beds, or with other people in a hospital-based environment. The purpose of what we're doing is to preserve and strengthen the child's family ties whenever possible. So that's why it's so important to get the services that's needed, whether or not it's services like home health care or other services. The other issue that we're still contending in this case is the definition of medical necessity. The definition of medical necessity for everything other than private duty nursing care in the state of Florida is it has to be necessary, and it must not be for the convenience of the caretaker. Well, it must not be only for the convenience of the caretaker. So we believe that something that is medically necessary, even if it may be for the convenience of the caretaker, should still be provided. Yes?
We've got a case where there's a very needy child, and the parent is trying everything. She has some to request ADA support and Medicaid support to have a child placed in the home and have 24-hour service or overnight service for the mother?
Absolutely. If the child is medically complex, you can get up to 24/7 medical care services. In addition, if the child's medically complex and it's a young child, there's also things called pediatric extended care centers, which are like daycare centers for children that could be from 8 to 12 hours a day. So there are services that are available, and then the best thing is schooling. Schools take kids with disabilities. So to the extent that the child can be in school, then the child could be out for 8 to 10 hours a day, even with a disability. So to the extent that the mother is able to parent the child with necessary accommodations, and the child gets the accommodation he needs or she needs, then it could happen, as long as it's for the best interest of the child that the parents are able to become parents. This is not a cure-all, but it is the way in which to level the playing field. So if a parent is able to parent, then a parent can be a parent. Any more questions? We have about 10 minutes for questions. No questions. Crickets. Yes?
Are there any community standards for these accommodations, for instance, if you're in a rural area where there aren't services available?
Oh, that's a very good question. You have to have the service available in order to know what to ask for. So if the service isn't available, you can't ask for it. ACA does have some requirements that services should be available at a certain location. And when that happens to me, what I do is, and the service providers aren't providing the services, I actually complain to ACA and I say, you have a contract with the service provider. How come you're not providing these services? And sometimes that helps to get services in more rural areas. And that's what I've usually seen. But going back to requesting an accommodation, it's important to know what accommodation you need to request. You just can't say my client needs help. The more information that you provide with regards to that specific help that the child needs, the better. Yes.
And issues, they take the child away from her mother, and she loses her Medicaid, so she can't pay for her medications. And then her case plan is medication management, take your meds. And so the judge, his opinion is DCF, pay for her meds.
Right.
And DCF is saying, that's not our job. So, this just happened, so I was wondering. That's what I'd be curious, because you said there's funds that they can get monies from, like if they can get gift cards, they should be able to get medication.
Yeah, and that's how you look at whether or not it's reasonable or not reasonable, because if they have other funds they're giving for gift cards, why aren't they giving them for medications?
Exactly.
Yeah, so basically, have the judge write in a nice red ink, indelible pen, pursuant to the ADA, they should get the medications as part of the plan. So much of this is awareness. It's awareness with the judges, and I'm going to do a similar training with the judges. And I'm going to be like, what do they need? How can they provide it? Write down, in order to have equal access in the program, in order to reunify the parents, pay for this program. Because when you look at one program, you're like, well, they're paying for
Right.
this.
They're paying for the parenting classes and the counseling. Why not pay for her medication? And
Right.
you're not going to give her her child back because she's not taking her medication.
So, for something, and it's the same issue that I was dealing with 8 hours of health care. You're not giving the child back because you need 8 hours of additional care. It's an accommodation under the ADA to provide those programs and service, just so she doesn't lose her child. And it's going to be a lot more expensive taking away the child. And that's the part that bothers me, but it's a good way to educate the judge to say, this is what the person needs. Now, in my materials that you'll find on the app, I have 3 really good issues. The first one is the notice from the Department of Justice and the Department of Health and Human Services as to the court's obligation with regards to dependency proceedings. And it goes into detail into that, and you can give that to the judge. The other one is I have the National Organization on Disabilities report it's called Rocking the Cradle. And it talks about parents with disabilities and the problems that parents have with disabilities when their children are removed, and the bias against parents with disabilities. And it goes into a ton of empirical research, if you want to do more reading on that.
I do that. I'm finding that, with all due respect to the department, my clients that have disabilities are not getting a fair shake. It's like they take their children and they want to give them back, and they're not helping.
And that's why it's important to, pursuant to the ADA, my client needs this accommodation. And it should be in the record. And then when they don't provide it, it's something that you can go back and say, they shouldn't have a TPR. All they needed was 3 weeks of medication until we can do the Medicaid appeal and get done with the Medicaid appeal so they can get their services. So for a stopgap measure until the appeal is done, it's entirely reasonable. To say that you're going to need it ad infinitum until the child is 18, that may be a fundamental alteration or an undue burden. But for a set period of time, it wouldn't be. And if anybody has any questions, you have all my information on the app. Has my picture, it has my website. Feel free to email me, call me, text me, tweet, Facebook. Thank you.